Hello everyone and welcome to class. My name is Professor Blue and I am really glad that you're here today. Today we are going to be talking about the death penalty. Now this is a death penalty law class, so if you're not supposed to be here, if you are not registered for this class, you may go ahead and get up. You may need to find another room. So I have been teaching this course for about 13 years now. I graduated from law school here and now I am back to teach. So I really enjoy this class. A lot of my area of expertise falls within the realm of constitutional law and capital punishment. So I've been doing studies on this for over a dozen years now. I'm really glad you're in this class. I hope that everyone has their book and also that you have read the assigned case that I gave today. So let's just go ahead and get right into it. I want to talk about the case of Enmund v. Florida. Now, can anyone give me the facts of the case? Yes, Ms. Smith. Okay. Right, exactly. So basically there was a getaway driver and then there happened to be a death, right? Now, did the getaway driver actually cause the death? No, that's right. Did he plan on causing the death? Was that someone else? Yes. That is correct. No, he did not plan to cause the death. That's right. And so tell me what happens in the case. Sure, you. Right. Exactly right. Yes. Okay, exactly. Yeah, the Supreme Court holds that the death penalty is unconstitutional for felony murder. And can someone please tell me what the felony murder rule is? Felony murder. Yes. Okay. Giving you a second to think. No one? Okay. So basically what the felony murder rule is, and it's okay that no one got it, it was maybe a little bit unclear in the reading, and this is the first class. So basically it says that if an individual causes someone's death during the course of another felony, then they are said to have committed felony murder. So why might that be controversial? Can anyone tell me? Okay, yeah, you. Yeah, sure, I can clarify the question. So basically I'm asking, why might that rule that says if someone dies while someone is committing a murder, why might that be controversial? Exactly, yes. The state does not have to prove intent to kill, and there's no mens rea at all. Yes, exactly. So, can anyone tell me now? Yes, okay. I'm just going through my notes here. Right. Okay, can anyone tell me what mens rea is? Okay, anyone? Yes, okay, good job. It is a particular state of mind. Yes, good job. Okay, so back to Enmund. You know what, let me write that on the board for you as well. Right. Okay, sure. Okay, so now I want to go over, sure. Oh yeah, that's fine. Okay, so now I want to go over a little bit more about the framework that the court uses to determine that capital punishment for the felony murder rule is unconstitutional. So let's go ahead and do that. So can anyone tell me how many parts to this framework there are? Yes. 2, that's right, yes, there are 2 parts. And so again, this is a little bit more complex, so I'm going to talk about it here. And then if you have questions or comments, please stop me at any time and we'll go over it. Okay, so the first part of this framework is what's called the objective indicia of evolving standards of decency. So essentially this looks at jury decisions and state laws. So basically it says, based on all the data that we have, are American people, are the American citizens today really comfortable with giving the death penalty for this offense? So in this case, they look at jury decisions and also state statutes or laws that are in place at the time. So at the time of Enmund, how many states had the death penalty or had a capital sentencing scheme in place for any felony murder? Can anyone tell me? No? Okay, at the time of Enmund, there were only 8 states that did offer the death penalty, had a sentencing scheme for any felony murder. Okay, so how many states or jurisdictions did not? Exactly, 42 jurisdictions did not have the death penalty at the time of Enmund for felony murder. Okay, so how many juries at the time? Right, the court mentions that only 3 jury decisions at the time out of more than 700 offered or gave the death penalty to a defendant with similar facts. Exactly. Right. Okay, so I'm going to put that over here. So remember it is objective indicia of evolving standards of decency, right? Okay, so let's go into the second part of the analysis. Can anyone tell me what it was called? Yes, you third from the back. Yeah. The proportionality analysis. Good job. Okay, so basically the proportionality analysis asks, does this serve society's purpose for the death penalty? So in general, the court will look to 2 things. They will look at retribution and deterrence and ask, does the death penalty for this type of crime serve the societal purposes of retribution, so basically justice and vengeance, and then also does it serve the purpose of deterrence? Will it deter or stop people from committing this crime in general? Now, many of you may have different opinions on this matter, whether any death penalty has a deterrent effect, but that's what the court looks at. So, what do they say in Enmund here? Yeah. Exactly, yes. They say that the death penalty does not serve any deterrent purpose, and that because people in this case often do not, I guess all the time, do not mean to kill at the time. This person in Enmund, they did not plan to kill anyone. They did not, they were not aware of any overarching criminal scheme to have someone end up dead at all. They had absolutely no intent to kill someone. Now that doesn't mean that what they did was not dangerous or wrong, of course, but the jury is just saying the court is saying that the person is not needing to be sentenced to death for something that they did not mean to do in taking the life of another person. Okay, and then as for retribution, yes, exactly. People who kill, who intend to kill, are, in the court's mind, most deserving of the death penalty, and Enmund had no intention to kill, so there's really no good argument for retribution when the person did not intend for there to be a death. Yes, okay. So in Enmund, the court looks structurally at a few other cases that we will read later. So that looks at cases like Coker, Tyson v. Arizona, Atkins, Roper, and Kennedy, which again we'll get to later in the semester. And yeah, okay, great. Sure, yeah, that's a great comment. Okay, yes, so additionally, basically this whole theme is that the Eighth Amendment forbids the death penalty or a capital sentencing scheme on people who do not kill, attempt to kill, intend to kill, who don't pull the trigger, who don't intend for a lethal force to be employed at all. Exactly. Yes. Okay, perfect. And then let's quickly go over Tyson v. Arizona while we are here. I also had to read that for today. So basically, I'll go over the facts real quick, which were that Ricky and Raymond Tyson, who were brothers, conspired with several other family members to help their father, Gary, escape from prison. Gary was serving life in prison for murdering a guard during a previous escape attempt. You know what, I'm gonna write this on the board as well. Yes. Okay. So essentially, they help Gary and his cellmate escape, and then they flag down and steal a passing car. They then killed the family that was in the car, and Gary died before the police found them of exposure, actually. So tell me, did the Supreme Court of Arizona affirm this sentence for the cellmate and the two brothers? Anyone? Okay, yes, exactly. The Supreme Court of Arizona did affirm the sentence, and they held that while the Tysons had not specifically intended to kill the family, they conspired with known killers and did nothing to aid the family getting out of the vehicle. Exactly. So they basically held that the son's anticipation that lethal force might be used in this endeavor satisfied the intent requirement for the death penalty to be constitutionally enacted. Exactly. Okay, so this was a decision once it got appealed and moved out to the Supreme Court. This was actually a 5-4 decision, so it was fairly close. Sandra Day O'Connor wrote the majority opinion here, and she and the majority vacated the lower court's judgments. They said that they basically remanded to determine whether the Tysons acted with a reckless indifference to human life. The court held that the anticipation of lethal force was not actually enough to satisfy the intent to kill requirement. So again, this is the Supreme Court of the United States, not the Supreme Court of Arizona. Yes, exactly. So there was a dissent. Yes, exactly. Can anyone tell me who wrote the dissent? Yeah. Yeah, exactly, Justice William J. Brennan, and he said that this case illustrates how arbitrary capital sentencing can be. Yes. He said the death penalty is always cruel and unusual punishment. Yeah, exactly. Any questions on that? No? Okay. It looks like we are out of time today, but I will have my office hours on Wednesday from 3 to 4, so if you want to make an appointment, please feel free. I am really excited for this semester, and if you have any other questions and can't make it to my office hours, feel free to shoot me an email. It's on the syllabus. If you did not pick one up, come down here and grab one on your way out. But it was great to see you all, and I will see you on Tuesday.